Any mention? May I please, Your Lordship? Your Lordship, I beg to mention item number 6. The conducting counsel is bereavement, Your Lordship. For respondents 7 and 8. No objection.
Preparing for respondent number?
7 and 8.
One prayer made on behalf of respondent number 7 and 8. One prayer made on behalf of the learned counsel, appearing for the respondent number 7 and 8, comma, is stated to be in, choose stated to be on body bereavement, comma, list is matter after
3 weeks.
3 weeks. Well, 3 weeks, all right?
Your Lordship.
Yes.
Obliged, Your Lordship. Your Lordship, I beg to mention item number 4, Your Lordship. May this matter come up after 2 weeks? Yes, 4.
I am for this time.
What is this matter, Mr. Sheikh?
Well, it is here that Mr. R. Gurung is here. He is not available today.
On the prayer made on behalf of the learned counsel for the petitioner, not objected to by the learned counsel appearing for the respondents, list is matter after 2 weeks.
Yes, Your Lordship.
Yes.
Obliged.
See, I beg to mention item number 7.
Yes.
On behalf of the state lordship. On behalf of the state. Here also that Mr. R. Gurung is appearing, but he is not available today, lordship.
Lordship, no objections.
For
2 weeks, lordship.
you're also there?
Private.
Prayer made on behalf of the state respondents, not object to the learned counsel for the petitioner, list after 2 weeks. Yes.
Master.
Obliged, Lordship.
May I please, my Lordship? I beg to mention item number 17, my Lordship.
Item 17.
My Lordship, this matter has recently been endorsed to me as a legal aid counsel for the appellant. And given the complexity of the case and the present stage at which it is listed, my Lordship, I humbly pray to grant me some time to prepare for the same.
17. Yes. You have already entered your appearance in this case.
This is my first appearance, my
You are
Lordship.
Archana Surana.
Yes, my
Your
Lordship.
name is reflected in the cause list.
Earlier, Dr. P. Agarwal was appearing.
But then her name is also reflected. Anyway, one prayer made by MS A. Surana, learned LLD, appearing for the appellant. When do you want it?
After 3 weeks, my Lordship.
It's all right.
List is matter after 3 weeks. You will not have any objection, Win.
Of course, Your Lordship. Oblige, Your Lordship.
Highly obliged, my Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 31, Your Lordship. Lordship, I kindly pray for 2 weeks' time, Your Lordship, in this matter.
Item 31.
Yes, Your Lordship.
One prayer for petitioner, list after 2 weeks. Yes.
Much obliged, Your Lordship. Lordship, I beg to make a mention of item 5, Lordship. This is a joint request from both sides, Lordship.
Yes. What is this matter? Nakmaship.
Lordship,
Yes.
it's a
On joint prayer made with the parties. When do you want it?
Lordship after 2 weeks.
List after 2 weeks. Yes.
Obliged, Lordship. Lordship, a similar prayer for item 8. Item 8, Lordship. Similar prayer, Lordship. Joint request for today, Lordship.
Any addition?
Together, no, try.
Oh, there is also joint prayer. There is also a joint prayer. Item 8
Lordship.
also a joint prayer.
Item number 8.
There is a joint prayer.
Yes, yes, Lordship.
Same order. Yes.
Oblige.
Highly obliged, Lordship.
Lordship, I beg to mention item number 12 and 13.
Yes.
Yes, this matter may come up after 2 weeks, Lordship.
On the prayer of the petition, list of activities. Yes.
Please, Your Lordship. Lordship, I beg to mention item number 30, my lord. I have informed the council for the other side. Matter may kindly be taken up next week, my lord.
Yes.
Yeah.
Any objection?
No objection.
Prayer on prayer made on the petition, list after 1 week. Yes.
Much obliged.
Supplementary cost list, item number 1.
Yes.
Lordship, this is an application for review of the judgment on order dated
Review of
6/8,
judgment
Lordship.
passed by this court.
Lordship. On 6/8/2025, Lordship.
Where is the judgment?
It was on 6/8/2025. Yeah.
Have you appended it with your petition?
Lordship, yes.
Yes. Where is that?
Page number 19.
Yes.
I may
What is-
draw
what
your
is wrong in
Lordship
it?
attention to para number 6 of my petition, Lordship. Page number 6. What has come up during the course of the hearing of the writ petition is that the application dated 21/5/2013 was not disposed of by the Contempt
Yes.
board, Shillong. Lordship may see
That
pa-
appears to
para
be a
number
stand of the
7.
cantonment board also.
Yes, I have served the call.
Yes.
The para number 7 of the application.
Yes. What is the ground you have taken here? Just tell us.
Ground is that, Lordship, the important point, that is, by their own admission, the writ petitioner has admitted that they had been communicated that their application could not be considered.
No, that is what we have sent it for consideration.
Lordship, so the matter stand is settled.
How? How?
2013
Do you want to say
application.
do you want to say that their application stood disposed of? It was considered and then some order was passed. You see,
Lordship,
that
they
would
were
not have been
already
otherwise-
intimated. What
Otherwise,
is I have
otherwise
quoted.
senior counsel would not have agreed with the order of the court. We do not know what kind of thing it is.
Lordship,
You have to see. You have to. You cannot go deep. We cannot.
it
go
is by
into
their own
rolling
admission.
play. Just say us what is the apparent error.
apparent error
If you
is
say
that, Lordship,
if you say that
the respondent,
contendent board had already disposed of, show us where is the order.
para number 7 of my petition, Lordship. Yes.
Of which
See,
petition?
of this review petition.
No. Where is the order by which contentment had disposed of that mutation application?
It was admitted by them, Lordship. Therefore, there was no occasion arise for this honorable court to pass an order directing
See,
that.
this is an order which was pronounced in the courtroom, isn't it? The order was passed in the courtroom. It's an oral order, isn't it?
Lordship,
And then senior counsel was present. Hence his
the
submission was.
subsequent application was of 2021.
Mr. Upadhyay, until and unless you can show us directly that it was disposed of, it cannot be. You see, like there cannot be any interference in review. To find out error apparent. That is why word apparent is used. So just show us what is the apparent error.
Lordship, may
We cannot go by presumptions that what who submitted.
para
what.
number 7 of my of my application, review application,
Yes.
where it is stated, the operative part of the aforesaid judgment is reproduced, Lordship.
Yes.
Now, 8.3,
Yes.
page 9,
Yes.
for that the writ petitioner has admitted in their letter dated 6/2/2021
Yes.
at para 6,
Okay.
annexure 18,
Wait, just
page
let
40.
us go to that. Or Mr. Mahanta, shall we issue notice?
No,
Lordship, yes.
Your Lordship,
Notice
today
must
morning
go
I
to the
got the
respondent
information that
Yes.
the mutation has not been disposed of even in 27 May 2024. They have intimated asking this court needed if Lordship wants to. Although Lordship, they send it by 4/2.
That has been disposed of.
No, not yet disposed. Not yet. This is the latest position. This is the latest position. If I am permitted to read, to raise your
It is
curtain
implied, you see,
holding the
otherwise,
document.
otherwise you would have brought it before.
Yes, I could have brought it.
And we have passed the order only to
No,
asking
there
them
is,
to consider.
I
Nothing
feel
else.
Lordship, there is no requirement of this.
Lordship,
Anyway, para annexure 18. Where is
annexure 18, page number 44 and 45 at para 6.
Page number 44, 45 of
Of the writ petition.
yes. This is what? This is
Annexure 18 of the writ petition.
yes,
This is the letter dated 6 February 2021,
yes.
where
Oh, this is a letter written by the
written by the writ petitioners.
yes,
Writ petitioners.
yes.
This letter was not under consideration at the time of hearing of the WPC.
Show us.
So at para number 6, Lordship,
Yes.
that is page 45, it is they have admitted that following the demise of my father, Anwar Haq, self and my brother Shri so and so have stepped into and applied for mutation of the said share of the leasehold right instead of our deceased father, and these also the above mentioned have put objection, and we are intimated that the mutation cannot be processed in our name until and unless the objection filed.
What is the disposal?
So
us
therefore,
something,
Lordship,
see,
it has been
Mr.
intimated
Upadhyay.
to them. It's
That is all right. You see, you can show the order passed by the cantonment board. Do not tell us to draw some inference from
Now,
any
Lordship,
document. That is a part of the representation written by this thing, isn't it? You have
This
to show
representation-
error apparent on the face.
Lordship
of
has not ordered for disposal of this
You cannot
representation.
take this court into all those things. If you have something direct, you show us.
So these shows that this is a letter of dated
So that is
21.
only thing. All right.
2021,
All right.
Lordship.
Yes. All right. Yes. Hard. Mr. S.T. Garden Council. And also Mr. Mahanta. See, you should make something acceptable thing. It's
Lordship,
not.
this
cannot
is
be
their
on-
own admission,
Cannot be on
Lordship.
inference and all.
This is their own
Counsel,
admission.
senior counsel for the cantonment board is appearing, and he himself is saying it has not been
This
disposed
is
of.
the today's
What more?
This
What
today's,
more you need? You see,
I will give
today
it
this one letter has been supplied.
are you trying to say that they have done something when they themselves are saying that they have not done?
Lordship may also
They are the authority, and you say they have done it.
also take into consideration that in the this writ petition, the cantonment board had filed an
See, you
affidavit.
should
through-
understand the limitation of review. And you have a right to raise your objection before that authority. That is what has been stated in the thing. So thereafter, there is no issue. You see,
No, apart from that, the civil suits are pending. There also no injunction. Nothing. So we'll dispose of the petition.
unnecessary you drag, come with these kind of things. Anyway. Hard, Mr. Seniority, Cabinet Council. And also Mr. S.P. Mahanta, Senior Counsel. Applying for the content board. And sit down, please sit down. So by this application, the petitioner has sought for review of the judgment and order dated 6/8/2025. Past WPC number 491 of 2021. Whereby a direction was issued to the Cantonment Board to consider the application of mutation filed by the writ petitioners stroke respondent number 1 to 4 in this application. In this instant petition. What we say, it is a review application, isn't it? We said address it as review application, isn't it? Not review petition.
Not review petition.
It's review application.
It should come under a High Court rules.
Stop. The sole ground taken in this review application. Give a paragraph. Just after paragraph, we just say the sole ground taken in this review application is that this court, while passing the judgment and order dated 6/8/2025, did not take into consideration the fact that the review application filed by the respondent number 1 to 4 herein already stood disposed of Stop. However, no such order of the Cantonment Board has been placed on record by the review applicant. Stop. Mr. S.P. Mahanto, London Senior Counsel, has non-senior counsel appearing for the Cantonment Board has vehemently refuted the contention of the review applicant and submitted that application concerning mutation of leasehold right of holding number 13 JB so and so, it will get it in that order earlier in the writ file, is still under consideration. Step. In support of submission, the Learned Senior Counsel has placed on record a communication dated 27th May 2024. If please furnish him a copy, kindly.
I
I have already furnished a copy.
27 May of 2024. Whereby certain documents have been conferred from the concerned party to the mutation. Stop. Paragraph in view of the submission made by the Honorable Senior Counsel. This court find that there was no apparent error committed by the court while passing the judgment and order dated 6/8/2025 in writ petition number 491 of 2021. Stop hence. Review of the said order is not called for. The review applications therefore stands rejected. There may be bit correction here, there in addition.
Item number 2.
Yes, my lord.
Yes.
Please, my lordship. My lord, just this is a miscase to writ petition 242 of 2025. My lord, I had filed this writ petition, just the facts of the little bit. I am the member secretary of the State Pollution Board from the State Forest Environment Department, and I draw a salary, my lord, of pay level 19. Pay level 19. Now, in the 2021 amendment rules in the Meghalaya Forest Service Third Amendment rules, my lord, they do away with level 18. They straightway have level 19. Now, my lord.
After 17, it is 19.
Yes, my lord. Now, my lord, as per the recent recommendations made under regulation 4 of the IAS appointment by selection regulation 1997, in case of non-state civil service officers for appointment to IAS, there is a rule.
You are what? Your name has been recommended.
Yes, my lord.
Then?
My name is recommended. Now what happened here, my lord? I filed my recommendation my representation letter on the my lord, on the 16 January 20.
What is your cause of action? What is your cause of action in this
My cause
case?
of action here in this miscase is that, my lord, if there's no transparency in the procedure of selection to IAS, then my lord, nominations will happen by hush-hush manners, which is not transparent.
There is no transparency. How do you say there is no transparency?
Because, my lord, they are supposed to have the screening committee has to come up with a syllabus. The screening committee has to involve the MPSC in these examinations.
Where it is laid down?
It is
where
laid
all
down.
those?
I have given examples, my lord. I also in my writ petition.
No, any procedure laid down, any written procedure
As
laid
per
down?
the state, no.
See,
But then,
the relief you have claimed
yes, my lord.
in this petition cannot be granted at the stage.
At this stage, I understand, my lord, because there's no repugnant.
It has to be after final adjudication.
Yes,
It's
but
not relief to be granted during.
yes, I understand that, my lord. But
that is in a pending writ petition.
Yes, there's a pending writ petition.
So what happened to the writ petition? Now, what is the change circumstances? Then you have come with this thing.
The
There
thing
is
is,
any interim order passed in the writ petition?
no, my lord.
Then what is the
My lord,
question
is because I have been waiting for the last 7 months to hear from them that what is the procedure, how do we go about. And the second thing is that, my lord, if I wait for 7 months and there's also a representation letter.
According to you, what your name has been recommended?
Yes, my
and then
lord.
what happened?
Nothing.
Now, after recommendation, what this has to be?
There has to be a written examination. There has to be a screening committee that will.
Who will hold it?
My lord, there is a committee here that I will tell you who this
Just
committee is.
tell us, just in short, just tell us.
Yes.
A committee formed by the state.
Yes, my lord.
Okay, so they will hold it.
Yes.
Now what happened? So after your recommendation,
Yes. Then
now
they will
you have not been allowed to sit in the test.
No, nothing like that, my lord. The screening committee has to come up with a syllabus. The screening committee has to come up with
at the time. If you see that something is conducted, any test has been
vacancy.
conducted, nothing.
Here, my lord, the vacancy is only of one post, which is only reserved for selection by selection. For non.
That is all right.
Non-civil service by
You
selection.
see, until and unless
Then, my lord, at this
you have
stage.
been ousted from the zone of consideration, you will not have any cause of action.
Then, my lord, if I wait for the repugnant list to come out, then, my lord, if
Your cause of action will arise there. How can we presume at the stage
then at this
that
stage.
you will not be selected?
No, my lord. What I'm saying is that at least this is what all I'm asking is that if the committee that is for screening has to come up with something, my lord, as of now, because there's nothing else now. They cannot
All along-
appoint.
No, this is not the first case. So far as your case is concerned,
Yes, my lord.
by the state, isn't it? Where name has been recommended for nomination. This happens. This is a regular course, isn't it? Now, all these years, what is the procedure adopted, and what is the
The procedure in the state of Meghalaya has not been laid down of date.
no? Then
I
what
can
what
explain.
was adopted all these years?
So all these years, my lord, the usual practice is that MPSC, I mean that is the state civil commission should come up with a syllabus, should come up with a screening committee, should come up with a procedure of how to select.
All along this was the procedure. Any instance? Have you cited any instance? Any example?
Yes, I have, my lord. That the
Just
previous
where is the syllabus published in earlier
no, they yes, I'll show you, my lord. This is my writ petition, my lord.
in your writ petition? The syllabus.
Usually there is a syllabus that has been prescribed
Yes.
by the central government, that is the UPSC.
That is
the state doesn't have
syllabus for, you see, like that that is in force for all those things, or for every examination.
Yes.
There are new
Yes,
syllabus.
that is after recommendation.
No, where the new syllabus comes up for every.
No, my lord, they have not. The state has not come up with anything.
Tell us the procedure you are saying.
I'm
about
telling
actual
you the
thing.
procedure, my lord, because the state does not have any procedure. Previously, also
So
they
then-
just after nomination, after
Then the
recommendation.
court is asking you the question that all these years, in
All-
which manner these tests are conducted?
Previous years, my lord, which is probably now maybe 7 or 8 years back, all they did was through recommendation, then nomination. They advised the central government, that is the UPSC. They had a personal interview, and he
Who
was
advise?
the state,
State. State means which official?
the personal department, and also the screening committee.
So
my
there
lord.
must be a screening committee, isn't
Yes,
it?
it's
So is it your case that no screening committee has been constituted?
The committee that has been constituted is there, but they do not prescribe the syllabus, my lord.
No, must be. They are prescribed the syllabus means what syllabus? Syllabus for what?
Syllabus for the screening procedure. There has
There
to
has
be
to be a
certain-
syllabus for the
Yes,
screening procedure, and you have
yes,
to be
yes.
made known to it. Well, just show us
I'll be
show us the law.
I can show you an example of the other states.
No,
Because
just
in
talk
Meghalaya-
about the Meghalaya. What happened?
Meghalaya, we
all
do
these
not
years?
have, my lord. We do not have. There's
Singhal-
nothing. We also.
Mr. Singhal,
We sought through RTIs and they did not
Matter
reply.
come up along with the main case, my lord.
Mental is coming
In
up
fact,
when?
the writ petitioner here.
Have you obtained instruction in the main writ petition? The things have become very complicated. We do not know.
In fact,
Until
my
unless-
lord, the petitioner herein, my lord, is not competent and he is not qualified to be
No, but then her name has been recommended. That is what.
not recommended,
I'm on
my
top
lord.
of the rank. I'm
from
number
the
one.
department,
Anyway, see,
it is not
see,
a recommendation, my lord.
It is not her grievance before this court that her name has not been recommended. So, forget about that thing. The thing is that the question which she is raising at this time, that there must be a syllabus, prescribed syllabus for the screening committee.
My lord, it is already governed by IAS appointment by selection regulation 1997.
Please,
But there's no
obtain
And
There's no
instruction.
syllabus.
See,
petitioner herein, my lord, do
Yes.
not have the requisite qualification for selection.
have you filed your affidavit?
I'll be filing, my lord, in the
Let
main
it come
case.
up along with this.
Yes.
My lord, in the
When
meantime,
when
may
it is
I-
coming up, the writ petition?
it was last listed 2 days back. My lord. After
2
2
days
weeks
back.
is coming. So my lord can.
Anyway, then just list this matter just in the case.
WPC
List
242
this
of
matter. You
2000.
see, you have to place it clearly. You see,
We
this
will.
court doesn't know anything.
We will. Yeah, I will.
You see, you
We'll
have
assist
to
the court.
enlighten us here, please.
We'll assist the court, my lord, because there's
Yes,
nothing.
Mr. Paul?
Yes.
There is no prayer that is against us. We have no role to claim. In the admission of the petition, there is no role as attributed as against us for the attribution of.
If you see the prayer is to adopt a fair process, you see. So, how can we presume that that will be unfair?
If I may draw your lordship's attention to the prayer.
Mr. Paul, we'll have it on the day on which writ petition. In the writ petition also you are a party, isn't it?
I mean, the
Yes,
petition itself.
So, you'll be filing your...
We have no role to
so, we'll see it whenever writ petition comes.
My lord, in the meantime, can they issue notice on this matter, on this miss case?
No, my lord, not
It's
necessary.
necessary.
It will come up on this... Come up on...
Second
this
session.
We'll just see. Because the writ petition already notice has been issued.
Yes,
What is the use?
And my lord, prayer also similar, my lord.
List it along with WPC.
On
number.
interim prayer is similar, my lord, to main prayer. But
Prayers
we
are
need to
not
hear
granted.
something from the state. If the state could come up
You
with
see,
something.
the prayer which you have made cannot be granted at the interim stage.
I understand that, my lord, but then we...
If you grant it, then nothing would remain in the
Nothing remains,
writ
my lord,
petition.
in the main case.
My lord, the thing is, it cannot be in hush and hush manner. There has to be something.
Just see, until and unless if anything happens, if something is done in hush and hush manner and then your candidature is rejected or something happens against you, We'll have cause of action. As of now, there is no cause of action.
In fact, it is not
Who is
maintainable, my lord.
MPC?
At this stage, my lord, is only that if there's a procedure that
Anyway,
can be
we'll
formed.
see.
Yeah.
Let it be listed.
Yes, my lord.
List it along with Miss case number 242 of 2025.
In the meantime, if we can file a counter affidavits, will be ready for the next date, my lord.
That is already there in the earlier made order passed in the rate petition.
Most obliged, my lord.
Daily cost list, item number 1.
My lords, we've not been able to complete service on the petitioner because he's on leave for the past 2 weeks.
No, what about you?
We are ready with the affidavit.
You have filed your affidavit? No.
My lords, without serving, it is difficult.
Oh, there is nobody.
No, my lords. Kindly grant me
It is
2
Mr.
weeks.
Jha?
Mr. Jha, yes.
Yes.
2 weeks, my lords.
One prayer by none appears for the petitioner. One prayer by Miss SCM, non-GA. 2 weeks time is granted for filing affidavit in opposition. Yes.
Great from you.
Item number 2.
His Lordship, the state respondent yet to file the affidavit, Lordship, it is there.
Your Honor,
Yes.
Please, kindly grant us 2 weeks, my lords. We've not received instructions yet.
This, what is the matter about, Mr. Sangma?
This is regarding the payment of only the gratuity, other benefit we have received it. This
Service
is a
benefit.
small issue, yes.
Service benefit.
Service
We've
benefit.
not received.
Like before? 2 weeks.
2 weeks.
You are the only respondent or there is
No,
other?
my lords. No, my lords. There is respondent number.
Yes.
None, just say, Mr. P.T. Sangma is present, so and so. Then you say on none
There is
appears.
the accountant general as well.
Yes, none appears for the rest of number 5. Then you say Miss SCM.
1 to 4.
Not G appearing for the rest of number 1 to 5. Is granted. Praise for end is granted. Praise for end is granted. 2 weeks time for filing affidavit in opposition. Yes.
Hearing, item
Much
number
less,
3.
Lordship.
Lord, I'm appearing on behalf of the council for the respondent number 4. He is, due to some personal difficulties, he's unable to appear, my lord.
Who is
S. Arlingdor. Respondent number 4.
yes, Mr. Paul?
Well, it's the state
All
was
along,
required.
all along, this matter was adjourned on your request. Mr. Lindo is otherwise very regular,
Personal difficulty, my lords, I have no
and he is otherwise very
my
regular.
lords. Only thing, my lords, the state was required to produce the records. I don't know if those records are.
You have procured the record.
No, Your Lordship, we just received the record this morning. So kindly have this matter tomorrow.
Some difficulty
No,
on
no,
behalf
she
of the
has-
council.
Tomorrow.
When can you?
1 week, my lord.
After a week.
Okay, on prayer. After 1 week.
My lords.
All right, my lord.
One prayer made. Wait. One prayer made on behalf of respondent number 4.
Number 4.
Yes. This is matter after 1 week. Yes.
Ali.
All right.
Item number 9.
Well, that I think the government, Mr. Hazarika,
Who is
Mr. Hazarika is representing the government.
Mr. Hajarika?
Yes, yes.
Mr. Paul is there.
I'm for the private respondent, my lords.
Again, state is absent.
I'll appear today, my lord.
You have to take up this for final hearing. Are you ready for that?
Today, Your Lordship?
Yes.
This call for hearing is good.
What is to be done? Mr. Khan.
Lordship will have to take time, Lordship. Who's there?
Hazarika.
State has a role here, Mr. Paul.
My lords.
So what is to be done?
Lordship, Mr. Hazarika is supposed to appear. I don't see him. Kindly, Lordship.
So we will record his absence. Or shall we say that you are praying on his behalf?
I am making a prayer on behalf of the state, my lord.
After?
After a week? 2 weeks? 2 weeks, my lord.
It's all right for you. Just say on prayer made by MSNG, Sheila Lander, Seniority. Appearing for the state respondents, this is matter after 2 weeks. Not just say not objected to by the land council of the place. Give a comma.
My lordship.
Yes.
Item number 10.
Again, Mr. Jha.
Lordship.
When shall we have it?
Lordship, after 2 weeks.
Non appears for the petitioner. MS Solar is present on view of the respondent. List after 2 weeks.
Much
Yes.
obliged, Lordship.
14.
My lord, we have finally settled the matter, my lord. The matter has been amicably settled.
Very good.
Well, finally. So, give me a week's time, my lord. I'll bring the compromise agreement on record. Matter can be disposed.
Okay. The landed, yes, landed council appearing of the parties submit that a compromise has been attained between the petitioner and respondent in this matter. Step. A prayer has been made to grant some time to allow the parties to bring on record the terms of settlement. Between the in terms of settlement entered into between the parties. Stop. Prayer allowed. List. After,
1 week, my lord.
after
Just
1 week. Yes.
Obliged.
15.
Will it come up?
Yes. This is that matter, my lord, where we are challenging an order by which, my lord, my application for recall of witness was rejected, my lord. But I have to very candidly admit, my lord, there's nothing in this case. My lord, we dispose of this matter, my lord, by... My lord, I have to make a very candid admission. There's nothing in this case, my lord. May kindly dispose it of my not in saying, my lord, or observing that there is nothing to interfere so far as the trial court order is concerned, my lord. We have examined this matter.
If we pass in 2 lines that order, then you will challenge it before a higher forum and you will say, you see, High Court has not discussed.
My lord can have it tomorrow, my lord. I'll just try and...
Not tomorrow, then after a week.
1 week.
Tomorrow will not be possible. Tomorrow this court also may not be here.
Let it be after a week, my lord. I'll try to...
Yes.
Lord.
Okay. On prayer made by Mr. Thapal, Landed Council appearing with the petitioner. List after a week. After a week, yes. Make sure you see if there is no use, why should you burden the court also, and why should... See, this court appreciates settlement, and especially with the matters where settlement is possible. And probably see the matter before you also. The initial parties, they were not at all inclined to settle, and now they have.
Yes.
So that is a better thing at least. You see, the parties will be happy. There will be no feelings of, like winning or losing. This will be a win-win situation for everyone.
Absolutely.
Obliged, my
Yes.
lord.
16.
Yes.
Please, Lordship. Lordship, I'm praying for to have some accommodation to this case, Lordship. Let it may come after 2 weeks because this is not actually not urgent matter, but then.
But then where you came here, we thought that you were ready to demolish the other side.
Yes. Actually, I wanted to make a machine doubling. I was late, Your Lordship, due to traffic jam. So I have requested the senior government advocate also.
No objection, Lordship.
Yes, on prayer made on the petitioner. Made by Mr. P.T. Sangma. Not council appear for the petitioners. Not objected to by Ms. N.G. Shilla. You are there?
Yes, Mr. M for respondent number 4.
And Mr. Coach. Is this matter after
2 weeks.
2 weeks?
Lordship. Much obliged, Lordship.
Deeply obliged, my lord.
18.
Yes.
My lords, pursuant to order dated 8th of July 2025, my lords, we have filed amended petition challenging order dated 18/3/2020. In the earlier petition, my lords, that order was not challenged because we did not had that order with us. Only after the trial court records were summoned that we were able to get that order. So, my lord, relevant amendment has been made to the petition, and
Where's the amended
the
petition?
order, it has been filed, my lords, on the 5th.
August, my lord. On the 5th of August.
Yes. You have
So,
received
my
a
lords,
copy?
Oh, yes, I've received a copy.
Yes.
so now, my lords, if your lordship takes up the order dated 18/3/2020, which is at page 80, the relevant part is at page 83. It starts, my lords, from page 79 onwards.
Yes.
And the relevant part, my lords, is at 83, where it says that in the month of December 2017, the petitioner, along with his family members,
Just a minute.
visited the
Can you
suit land.
refresh the court, Mr. Pandey, about this
Yes,
matter?
my lords, what had happened in this case was that, my lords, the district council court had passed an ad interim injunction against my lords, MECL. A substation was being constructed at the site.
MECL.
And about,
MECL was a party before district council.
No, madam. No, Mr. Party.
no, my lord.
Private respondent.
So that is primarily our concern, my lords, that the corporation could not have been made a party, and behind the back of the corporation, the interim orders were granted, stopping the construction of the substation at the site.
Okay, so this was
And
case means where an injunction order was passed by the district council, and that
yes, my
injunction
lords.
order was sought to be implemented against you.
Yes,
That is the case, isn't it?
that is the yes, my lords.
And your argument was
So
that
that
this MECL was not a party before district council, could not have been also. They could not be made party.
yes,
And then since district council court has no jurisdiction over you, could not have passed the order.
yes, my lords. That is precisely the case.
Is this the
It's
case? That
a
was the case,
question
isn't
about
it? If this
yes, yes, my lords. The question basically is about the extent of power of a district council court when one of the parties on the face of it is a non-tribal.
yes, but then he has not been formally made a
And
party, isn't it?
yes, so here, my lords, from the order itself, it is apparent at page 83, the relevant part at page 83, where it is mentioned. This is in pursuance of Order 39 of the CPC, which is in respect of an interim injunction.
Yes.
It was in the month of December 2017, the petitioner, along with
You
his
are reading
family
page. You are
members,
reading page.
83, my lords. I am reading the relevant part of the order at page 83.
Yes, please.
It says, my lords, it was in the month of December 2017, the petitioner, along with his family members, visited the suit land, and during such visit, the petitioner was shocked to find that some 3 to 4 laborers of to develop the suit land for the purpose to set up a powerhouse. On inquiry, he was informed that they were permitted to use the suit land by the opposite party numbers. Furthermore, the opposite parties number 1 and 2 came to visit the petitioner at his residence, inducing the petitioner to believing that since the petitioner has failed to take care of the suit land, they have decided that the petitioner's right, title and interest over the suit land has ceased to exist. So the contention of the petitioner, my lords, before the district council court, or rather the plaintiff before the district council court, was that he came to know about the cause of action upon finding out that 3 to 4 laborers of the MECL were constructing at site. Apparently, I was at site and I was in possession of the site that has been conceded by the plaintiff. And thereafter, my lords, at page 85 is the order. Heard at length the learned counsel for the petitioner, I have perused the instant application along with the plaint, which is part and parcel of the instant application. After bare perusal of documents on record, the petitioner has a strong prima facie case as he is in possession of the suit land, having rented it out for cultivation to Shri so-and-so for a period of 40 years. Therefore, if the petitioner has inherited the suit land out of which 50% of he is entitled to, as such, he has every right over the suit land. Hence, the balance of convenience is also in favor. And will also the subsequent paragraph, in light of the above, the opposite parties, the employees, agents, associates, or any other persons.
That is common.
Are
That is common thing which is. See. Any other
So,
person
Milords,
would mean a person under him only.
Under him, Milords, an injunction has been passed, are restrained from entering and trespassing the suit land or disturbing the peaceful possession of the petitioner over the suit land.
Then what do you do at
So
this time
based,
now? In this revision,
yes, Milords.
what remedy you are seeking?
Milords, I am seeking the setting aside of the injunction orders.
And then you have no problem with the suit proceeding against you.
Because the suit may come to an ultimate conclusion.
But then see, just because an injunction order has been passed, by taking note that your employees were found working there.
Yes.
Would it be
And Milords, kindly seize the suit
injunction order?
Yes, but
be something like that. You may contend that this injunction should not be applied against you.
Yes.
Yes, Mr.
So-
1 minute. Yes, Mr. Sangma. Yes.
Your Lordships, if your Lordships recollect, at the very outset, I've raised the issue of maintainability of the instant petition filed by the petitioners. No, my lord, here, firstly, the order impugned has been passed by the civil court. My lord, whether rightly or wrongly, whether they're a party or not. But this is not the proper forum, my lord, challenging the impugned order. No, my lord, we may take your Lordships to the plain, my lord.
No, why you are challenging the maintainability? On what ground?
But here, firstly, my lord, the supervisory power under 2 to 7, my lord, it's only to the extent that your Lordships has to see whether there's any errors committed, my lord, by the trial court, but not to overturn the original jurisdiction of the civil court, my lord.
Is it not that the court has taken note of the fact?
My lord, yes.
That and then in spite decided to pass an order of injunction. Is it not something stepping beyond
that
the
I'm not disputing,
jurisdiction?
my lord, since that is my admission on my plane. That I'm not disputing, my lord. No, my lord, in fact, my lord.
Now, if you say about maintainability, we are interested to know why maintainability. Because MSCB is not a party here.
Not a party.
There is no question of, you see, resorting to normal provision of revision under 115 or Rule 6 and all.
My lord. Yeah, firstly, my lord, they are non-party to the suit, for which, my lord, I have informed this court that there's decisions, authorities.
No, you do not apply this injunction order against them. Then matter would end here. All the controversy would go.
In fact, my lord, we have instituted a fresh suit, my lord, before the regular courts against the MECL, anti-private respondent. My lord, yes, a fresh suit.
So that is okay. Then this injunction order can be interfered with, and your remedy will lie before that suit, wherever you file the suit.
No, but again, my lords,
What is the suit you have filed?
My lord, if it please your lordships, the plain.
Yes, Mr. Pandey, have you taken note of the...
My lord, we have already issued notice to the MECL, my lord.
Whether Mr. Pandey has... Mr. Pandey...
On that aspect, well, that all the more proves that the order which has been passed...
What is the... Do you have the thing? Do you have the details of that suit? with you?
No, my lords, I have not received
You should obtain
instructions
it
of
because that comes to your advantage.
My lord, they've already been served on 12/7/2025.
I have, my lords, not received any details, but going by the admission of my learned friend, my lords, that itself shows that this order has been passed
My
without
lord, here in
jurisdiction.
the instance, my lord, we have challenged the sale deed. Because this
And
was within our knowledge only at the time of filing of the
That
revision.
is okay, Mr. Sangma. You see, the thing is that the court's concern is that only which way you see that order can be implemented against MEC. That is the main thing.
But again, my lord, if lordships
Otherwise, they are
interfere,
not interested to know merits of your
my
case. Not at all concerned. Because if you go into the question whether a sale deed could have been executed or not, everything, there will many things will come up. It will be kind of, you see, like.
But again, your lordships interfere with the impugned order. That is my purpose of filing the instance suit also, my lord.
No, since you have already instituted a suit.
My lord.
Before another court, so we'll just make clear that this injunction order passed against should not be implemented against this.
But again, my lord, that my suit will become infructuous.
Which suit?
The instance suit which has been
No,
filed.
but then you have already instituted it is in your
Because here, my lord, we have filed an application
Mr.
for
Pandey, you
injunction
give
as
us the number of those suit which Mr. Sangma is.
My lord, title suit number 60 of 2025.
We'll take note of that and we'll just say that since you have already obtained that suit, then this order should not be implemented. Instead of going into all other questions. Because if we make some observation at this stage, this may have some bearing on your suit also. The final outcome may be affected. Who is the defendant in your suit?
My lord, the MECL as well as the private respondents, my lord, the respondents 2
Who are the private respondents?
The respondent number 2.
Are they appearing? Have they entered appearance?
No, just notice has been issued.
Whether they have entered appearance or not?
No, my lord, the next matter, the next date is on the first week of September.
No, before this court.
Only respondent number.
No, this is in your suit before the district council. Who are the parties? Who are the defendants?
My lord, the parties are right here in the revision petition.
Yes, and have they appeared?
My lord, they appeared. They filed a counter. They have filed written statement as well.
Because here they are made parties.
Here, my lord, only
They
respondent 2 and 3.
Yes, Mr. Pandey.
because they are made parties, but they have not entered appearance. My lords. From the very inception, they have not.
Service of notice.
Yes, my lords. They have not. Yes.
And they are the people from whom you have procured the land, isn't it?
Yes, yes, my lords.
They are not coming.
My lords,
Yes.
they are not coming forward, my lords. Maybe for whatever reason.
Entered appearance through Z. Longanri.
That's for number 3.
My lord. This is the village Dorbar of Umtong, which the MSL have purchased the land.
Yes,
Now, the thing is that you see,
now, my lords, here, yes, my lords, as far as this case is concerned, right from the suit to the pleadings to the order, it is apparent that it has been passed with a view that MECL is there on the site. On the last date of hearing, also, your lordship had put a question to my learned friend whether he is accepting to the situation that this order would not be implemented against MECL. My learned friend, refused to that suggestion.
no, but
So,
then see that seems to be the only way out right now, because this court basically would not like to go into to determine the entire situation here, because it may have some bearing on the final outcome of the suit, which is pending before district council.
Yes, my lords. I'm not, my lords, even asking your
We do
lordship.
not want to prejudice the case of the plaintiff before the district council. But then at the same time, court is concerned that this order should not be implemented against you.
Yes.
So
Yes,
that is the purpose. That
Yes,
is the
my lords.
purpose.
Well, if that's the case, my
And
lord,
more-
grant me a week's time, and I'll just seek instructions on this. On your lordship's
No, the issue is
Okay,
there
it
is
is
no
better
question.
if you have instruction, then we can
A week's time
finish
will be
it or
fine.
small thing, or otherwise we'll proceed to pass order. Just take into consideration
No,
that
lots of
passing
suggestion, I'll seek
of
instruction.
order by this court may have some bearing the outcome also. So we'll have it on this thing, Mr. Pandey. Let him obtain instruction.
Next week.
My lords,
Another week. Okay. just had landed counsel for the parties. Made by Mr. Sharma. You are appearing for the respondent number?
Correspondent number 1, my lord.
And therefore number 6 actually. We're only the implementing agency. Power grid.
You have no direct role to play here.
Well, yes, isn't it? More or less supporting the case of the petitioners.
We want the project to continue.
Okay. Anyway, what is it as per his answer? This is matter after 1 week to enable him to obtain necessary instruction.
20.
All right.
Obliged.
Yes.
Please, Your Lordship. Your Lordship, I pray that this matter be taken up at the end of the board as the leading counsel is in mediation as of now.
What more matter we have?
2 more matters.
These are the last item, Your Lordship.
Your Honor, item 33 is the last.
So this is the last item.
John, no? John, it's still there. 32. 32.
Okay, just wait for 2 minutes.
Lordship.
Yes.
32.
After at the end of the board. Yes.
Well, it's this is that matter.
Oh,
where,
Mr. Shen's thing.
my lords,
Yes.
well, I am instructed that probably the talks of settlement have not gone very favorably. I'm yet to take an instruction on that aspect. However, my lords, today we're making a prayer. My lords, we wanted to file an additional affidavit, bringing certain documents on record.
What is the purpose? It's a quashing application only.
Well, I quite
Court will
understand.
not go to determine each and every.
No, not on that, my lords. That even I quite bow down to that.
No compromise. Yes.
Settlement, my lords, has not gone ahead as planned. I had thought, my lords, probably this matter could have been
That
put
was
to
your
rest.
submission at the initial stage. This court, remember. Basing on which you passed.
I was hoping, my lords, that this matter could have been put to rest.
Yes, this court also was hoping, especially when you said that you will.
Well, let's be that as it may, my lords, I will also take up this matter. My lords, may kindly give us this indulgence of filing an affidavit, and in the meantime, my lords, we will see what can be done. Idly, my lords, it's not a matter that I like
This is
arguing
a
before this
criminal
court.
petition.
My lords.
What is the need of filing affidavit for affidavit?
My lords, one affidavit only bringing out, my lords, what happened in terms of this orders passed by this court. After that, whatever were the offers made, my lords, that we want to bring it
We
on.
have not recorded anything about the compromise. Well, that has not been indicated in any of the orders.
My lords, in the first order, my lords, it has come.
That is only on the
My
understanding, and since learned member bar is
My submission
was involved.
My submission only to that limited extent.
Well, the only case that my learned senior can argue at this stage is whether a notice can be sent after a prolonged period of time. Now, my lord, that is what the investigating agency has done. What I have done is bona fidely file an FIR. And my lord, if there is any fault on the part of the state, my lord, I should not be prejudiced.
Mr. Senior Counsel has not opened up his case. He has not
No,
argued
no, no,
anything
well, he's
on
not.
that.
He's
Yes,
not.
Okay, only one. The prayer what has been made is that there should be given a chance to file an affidavit, bringing on record the development with regard to the compromise.
The only development is that, my lord, there
But
is
then
some.
what bearing that will have in the outcome of this case?
I am under instructions, my lords, they want to bring it on record.
See, instruction cannot bind a
No, my
Senior
lords.
Counsel.
Which is why I prayed.
Take into consideration what is needed.
Because my lords would otherwise decide the matter on what is on record, my lords.
That is what we should do.
Otherwise, let this
Unless
affidavit.
you say that some information or some material will have some bearing, that is the only thing. But then whether it is compromised or not compromised,
No, we are saying that my lord, the settlement is not worked out. So we are ready to go for hearing. Because, my lord, some offer was made. My lord, the offer itself was, my lord, the way it was made is something which really, my lord, very wrong
doesn't
approach.
satisfy
We are not here. We are not here to, my lord, the FIR was not filed to make money. My lord, lordship will understand. If, my lord, my client wanted to, my lord, unnecessary, my lord, harass the company, he would have followed the FIR. He filed the FIR, he let the investigating agencies take its own, whatever they wanted to do. If they issued notice after a certain period of time, my lord, it is not my fault.
that's okay.
My lords, I am not getting into
See,
the merits as I have submitted.
Whether you are fault or no fault, that is also not the question here. Whether that could have been done or not, that is the main thing.
So, my lord, even if notice could not have been issued after a certain period of time, that would not be a entire
See, what
to
we
quash
see
the
is
entire
that
proceedings.
what we see is that whether the allegation made in the FIR prima facie constitutes
Constitutes an offence or not.
An offence or not.
Yes.
So that limited extent, my lords, we'll file the affidavit and my lords may have it after a week. In the meantime, as I submitted, my lords, with all right earnest, I had told my friend also, this is not one of those matters that is needs adjudication. Probably, my lords, we'll see what can be done. I'm not making any submission, but we'll see, my lords. Probably, ideally, we can come back to your lordships and say that this matter has been resolved.
This court also desired to see that some compromise is achieved here.
My lords.
Especially because a member of the bar is.
I bow down to that.
That is what. And,
but I had submitted it the first occasion.
That is what is.
We'll see, my lords, what can be done. In the meantime, my lords, I'll just file the affidavit, and my lords may have it after 2 weeks. In the meantime, we'll see what.
Sir, mediation will help you.
Well, senior counsel is there.
Mediation will help you, not then we can send it to mediation.
My lords may not be necessary.
Senior counsel is here. Very well.
I'll see, my lords, what can be done.
So when shall we have it?
After 2 weeks, my lords.
So we are not saying anything about your filing of affidavit.
Well, otherwise I'll not be able to file it. May allow us to bring it on record.
At least you will not say like allow you to file an affidavit, or it is not required for the court to see what development had taken place.
We'll just bring it on record. In the meantime, my lords, as I submitted, this is not one of those matters, my lords, ideally we would need to argue before, my lords. I will see personally what can be done in this matter. My friend is here, my lords. We don't want this matter to really go to that extent.
Senior counsel has made a submission.
Mr. Capel, Leonard, Senior Counsel, assisted by so submits that an affidavit. But then we have not recorded anything in work.
Not necessary, my lords. May just record my prayer that I'm wanting to file an affidavit, my lords, to that limited extent. Your lordships have not gone into the merits of the affidavit at this stage.
Okay. What is it, Mr. An additional affidavit is required to be filed by the petitioner before this matter is taken up for final hearing. Mr. Gautam Lanet, counsel appearing for the respondent, has no objection. State is not a party here.
State is a party.
Who is appearing for this state?
On the first day, Mr. Khan was there.
This is something, Mr. Sulai. See, this is something you see. This is something you see. We do not know if you want the court to pass some order and send it to. We'll do it.
How many times shall monitor also?
It doesn't give a. You see, like it's not a pleasure for the court. You see, like, but then this is happening. It's a recurring. For the state councils, whenever they see that there is an opportunity, their appearance is not required. They are not here. Anyway, we'll.
It's unfortunate, my lords. I've noticed this in this court today.
It's happening, Mr. Paul. It is not not only today.
No, my lords. I'm sure, my lords.
And then, if the court passes any order, then subsequently you will find that this court is very harsh and court is not. That's the problem. Myself was a member of the bar for such a long time. Would not like to do this kind. But then negligence is one thing.
It should not be like this.
See, it should be the last thing in the problem.
Should not be like this. I think my
lawyer
seniors
coming,
here,
appearing, asking for time, that is one thing. But then the default should not be there. Mr. So-and-so. Appearing for you are for the respondent number? You are respondent number?
2. Well, 2. I'm 2. I'm 2.
Has no
State is 1.
The pyramid. No, none. There is no appearance for the state respondents. We are not recording your name.
Lordships.
There is no appearance for the. On behalf of the respondent number 1. Maybe just say. Just next person, just in view. The. I mean, just a prayer. Do not say in view of the. Just prayer made. In view of the petitioner is allowed. The additional affidavit may be filed within a period of 2 weeks.
2.
List accordingly.
Obliged.
Obliged.
33.
Yes. Hello. Oh, that is those. Seniority.
Seniority. I'm almost at the end of my submissions. Just 3 very short submissions I have left, my lord. On the last date also, I had started with the first submission. This is regarding the apparent conflict between Rule 23, my lord, and Rule 16.4 of the MCS rules. Rule 23, if Lordship recalls, states that selection board will prepare a list and seniority for the purpose of promotion will be as per that list prepared by selection board. So the contention is being advanced, is being sought to be advanced, that my seniority in the service will depend on my place in the selection board list. But Rule 23 is very clear, my lord. Rule 23 says that selection board will prepare a list and seniority for the purpose of promotion, not in the service, for the purpose of promotion will be determined by that list. Whereas 16.4 says my seniority in the service will be determined by my place in the merit list, my lord.
Let us come to 23. Just
Yes.
let us read it.
23, if Lordship kindly sees.
Where's the rule? Give me the rule.
What is your plea? Plea in the writ petition, Mister.
The plea is to
What is the grounds you have raised in your writ petition?
My lord, my ground is very simple, my lord, that my seniority in the service can only be determined under 16.4. 16.4 says seniority is to be determined on the basis of the merit list. So in the merit list, I am senior to private respondent. So therefore, that seniority has to be maintained in the gradation list which we have challenged. In the gradation lists which we have challenged, they have been put ahead of me. They have been put ahead of me because they received appointment 2 years prior to me. So all of us were recruited on the same date.
There was a round of litigation. You challenged their seniority.
No.
And then.
No.
Rather they challenged.
They challenged.
And that was allowed.
Just as Banerjee said, as far as the entry level post is concerned, they will be senior. But Justice Banerjee also said that I am not talking of what happens after promotions. So now we have been promoted to the senior level. So now we have to go back to the rules. As per the rules, 16.4, my seniority is to be determined on the basis of the merit list. That is not being done in the impugned gradation list. If Lordship kindly looks at page 66 of the writ petition. Page 66, my lord.
Yes.
Page 66, my lord, is the gradation, the impugned gradation list which we are challenging. Just the first line, my lord, the provisional gradation list of the members of the Meghalaya Civil Service as per Rule 16.4 of the MCS rules is hereby published, so and so, so and so. So this impugned, the gradation list which we are challenging claims to be based on 16.4. 16.4 says seniority is to be on the basis of place in the merit list. But gradation list does not reflect that. Gradation list reflects something else. If merit list is to be the basis under 16.4, my name has to be above.
This seniority list parties to the promotional post.
My lord.
This is after the promotion was accorded. This concerns promotional post.
Yes, madam. This is for the senior grade.
This was the senior grade.
Yes, madam. So we received promotion on the same date. Once promotion was granted, gradation list was subsequently published, claiming to be under 16.4, but it does not reflect the correct position. If it is indeed under 16.4, which it has to be, then position in the merit list has to be reflected in the gradation list. In other words, my name has to be above.
Otherwise, just your contention is that if it is according to rules 16.4,
yes,
in such a situation you have to be placed above the private response.
That's one submission, my lord. Second submission, in fact, very recently, Supreme Court was seized of a very similar matter, my lord. This matter in the Supreme Court arose out of, this was in May 2025, if Lordship allows me to. Lordship, our matter, my lord, in our matter, private respondents are seeking seniority on the basis of the fact that they were appointed 2 years prior to me. They receive appointment 2 years prior to me because of the reservation policy, etc., my lord. So only on that basis, they are seeking seniority over me, my lord. This matter, this Supreme Court judgment was a very similar matter, my lord. In this matter, Tamil Nadu government issued a notification calling for examination for the post of sub-inspectors, my lord. 50% was reserved for serving head constables, 50% for open market, fresh candidates, my lord. Subsequently, another notification was issued, my lord, where 20% more was reserved for serving head constables, 30% left for the the other candidates.
70-30.
70-30.
From 50-50, it becomes 70-30.
70-30. And more importantly, my lord, the notification also said that 20% who has come into the, who has been added, the 20% head constables will be senior to the open market candidates. Only because, again, the same logic, my lord, they've been in service before the other candidates, my lord. In that context, Supreme Court, my lord, has passed a very instructive judgment. If Lordship kindly looks at this judgment, para 22, my lord. That is internal page 34, para 22.
Yes.
Para 22, my lord.
Yes.
I'll just read, my lord. The state government, without amending the recruitment rules right from 1995, continued with the appointing process under the direct recruitment category by appointing in-service candidates. And in the considered opinion of this court, such a recourse was not available to the state government without amending the recruitment rules. However, in light of the fact that the persons have been promoted in 1995 and therefore also this court is not touching upon their promotion orders, the state government, without amending recruitment rules till 2017, continued to appoint sub-inspector of police from head constables serving the police department, and all such recruitments were made without amending the recruitment rules. The recruitment rules were amended only in the year 2017. In the considered opinion of this court, the amendment to the recruitment rules in the year 2017, to the extent it provides for 20% reservation under the direct recruitment category to the in-service candidates, does not warrant any interference. This is important, my lord. However, the amendment brought wide geo-dated so-and-so, amending Rule so-and-so of 1955 rules, which provides for grant of seniority to all the in-service candidates over and above candidates recruited from the open market, is certainly violative of Articles 14, 16, and 21 of the Constitution of India and deserves to be struck down by this court. So the attempt of the government to grant seniority to serving members, to members who are already in service, that was not agreed to by the Supreme Court. Supreme Court said that that's violative of Articles 14, 16, and 21, my lord. Moving on, my lord, para 25. Para 25, this court, in the case of Dinesh Kumar Gupta versus High Court of Judicature, Rajasthan so-and-so, was dealing with the seniority issue of district judges promoted through limited competitive examination. in the aforesaid case, it has been held that inter se placing of candidates selected through limited competitive examination has to be based upon merit. Paras 48, 49 and 50 of the aforesaid judgment reads as under. The judgment is extracted. I'll skip this part, my lord. Next page, bottom, my lord, in the aforesaid case. In the aforesaid case, there was a dispute in respect of inter se seniority of persons who were appointed to the service under the limited departmental examination. The High Court granted seniority based upon their past service. However, this court in the aforesaid case also held that once an appointment to service is made based upon a competitive examination, the seniority has to be maintained on the basis of performance in the examination and not by taking into account the past service alone. Similar principles are in the other paragraphs also. If Lordship looks at
that matter, probably the particular provision of the rule was under challenge.
In this judgment, my lord?
In this judgment. That is where...
Yes.
That 25A.
My lord, there was a government notification was there, so that was challenged. The principle, but it is the principle which I'm relying on. When Supreme Court says that to grant seniority to persons who are already in service, that is violative of Article 14, 16, 21.
When the selection is made on the basis of competition.
So there is a common examination. Everyone appears for the common examination, but you give seniority to someone who simply on the basis that they were already in service. Same as our position. Seniority is being sought by private respondents because they were 2 years ahead of me in terms of appointment.
So in such a case, the decision of the division bench.
Yes, madam.
Should have been challenged then if you say that is the...
No. Division bench, my lord, that was a different judgment. Justice Banerjee's was a single judgment. And in fact, Justice Banerjee himself, sitting with my lord.
Justice Banerjee's judgment, the single bench.
Yes, madam.
This was concerning the same parties here.
Same parties, my lord.
And then that judgment has not been challenged.
No, it has not been, because there was, very, very respectfully, my lord, there was nothing to challenge in that judgment. Because that judgment addressed a situation regarding the entry-level post. So as far as entry level...
But then the thing is that if you take into consideration that you were placed higher in the merit list,
yes,
then...
Yes,
then you lost your seniority because of the judgment.
As far as entry-level post is concerned, my lord, because the fact that we did not challenge it is it's not in dispute. Obviously, there was, as I said, there was nothing for us to challenge because 1 month after the judgment, less than a month after the judgment, we received.
Once the factual position remains pursuant to that single bench judgment.
Yes, madam.
Then which way proposition of this judgment can be made applicable?
The
Supreme Court judgment.
The Supreme Court judgment, my lord. The Supreme Court judgment, my lord, the single judge, Justice Banerjee's judgment, addressed or dealt with a very specific issue. The issue being seniority as far as entry-level post is concerned. That issue, Justice Banerjee decided.
It is not that is the foundation so far as seniority is concerned. It is not that then just after these concerned people,
yes, madam,
they cease to hold that the original post and promote it to some other post.
Yes, madam.
This entire situation will get altered.
The situation changes because of the promotion, madam. Because Justice Banerjee...
It means if there is a change in the situation of seniority.
Yes, madam.
After promotion.
Yes, madam.
Then definitely it will be determined by the merits in the selection conducted for promotion.
Yes, my lord. I think...
if you have to apply the Supreme Court's proposition.
My lord, I think Lordship is talking the same thing that I am talking. If Lordship is taking the view that once promotion is conducted, the seniority has to be determined as per the merit. That means the original merit list.
I am not saying this court is in the course of discussion. Now you have placed
this judgment.
A decision of the appeal.
Yes, madam. Yes, my lord. So this judgment, my lord.
What we got from this thing is that just because somebody is senior in the department or somebody was there already in the department, just because of that he cannot be given seniority.
Absolutely.
By ignoring the merits.
The
selection.
Yes.
When they are recruited or maybe.
Yes, madam.
But then,
that is my case, madam. That is my case.
Perhaps the court's understanding also is not correct.
If Lordship allows, para 27 may sort of clarify this issue a little further.
No, because you see now, the argument which you are raising,
yes, madam,
it's making things a bit more complicated. More complicated in the sense, you see, like the factual scenario here. Even after the pronounced judicial decision,
yes,
and the law which is sought to be placed by you,
yes, madam,
or something not telling, like
my lord, if there was no promotion, we would have definitely had to challenge that Justice Banerjee's judgment. But knowing fully well that promotion is just a few days away,
see,
and
Justice Banerjee's judgment has settled your promotion.
Settled a position as far as entry level, my lord.
For so far as the entry level post.
Entry level post.
Now that is over. That situation continues.
That's gone, my lord.
Now, according to you, that after all of you were promoted to senior grade,
yes,
the situation has taken a different turn. There is a change in the situation.
Yes, ma'am.
Now, this is not your case that in the in your promotion to the senior scale,
yes, ma'am,
you were on the top of the merit list, and
yes,
the respondents were below you.
Below.
And then, but then in spite of that, they were given seniority.
In the impugned gradation list, my lord. And that is the ground of challenge. That is the ground of challenge.
What that means, that Rule 22 and 23 will come into play.
If Lordship just allows me to complete this judgment, para 27.
Yes, please.
Para 27. Para 27, my lord, from the bottom fifth line,
yes,
therefore, this court. I'll read, my lord. Therefore, this court is of the Therefore, this court is of the considered opinion that all seniority lists right from 1995 deserve to be recasted by assigning proper seniority to the candidates who have been appointed from the open market as well as from in-service candidates solely on the basis of ranks assigned to the selected candidates by the appointing authority on the basis of marks obtained by them in the examination, on the basis of which they have been selected and appointed to the post of Sub-Inspector of Police. There is no other process which can be followed in the present case.
But then, see, this thing,
yes, madam,
this situation is not present in the present case, in the instant case. This situation is something different.
No, why yes.
Here, basically, Apex Court was dealing with a situation where there were candidates from amongst the department who were appointed on promotion and some by direct.
Yes.
Now that is the situation.
That is the situation.
Now, but then in the present case,
yes,
so far as the cause of action is concerned, situation is not the same.
If Lordship allows me to kindly and humbly, respectfully disagrees a little bit with what Lordship is saying.
No, see, court is putting a query. There is no question of agreeing and disagreeing.
My lord,
court is not giving any
opinion. Understood, my lord. There is similarity. My humble response would be there is similarity for the reason that the seniority which they are seeking and which has been granted to them under the impugned gradation list is based solely on their on the fact that they were in service 2 years prior to me. They received their appointment 2 years prior to me. In this case also, head constables were in service prior to open market candidates. Solely on that basis, Tamil Nadu government said head constables appointed to sub-inspectors will be senior to open market candidates. Why? Because they were already in the department before the open market candidates. That is where the similarity is with our case. Their seniority is based only on the fact that they received appointment 2 years before me. That cannot be the basis, my lord. As per Supreme Court, that cannot be the service you may have already rendered cannot be the basis when there is a examination that has been conducted. In our case also, 2010.
Even then, bit confusion remains. In the sense that in that case, there were direct recruitees.
Yes, my lord.
So far as in our case, at the present cause of action, there is no direct.
That is where the difference is. But I'm banking.
Only thing is that what you are trying to say, that the basis was that, that the
head constables
they entered service before
the others.
Yes, before the others, and that is so. That is what has Apex Court has not correct. So here also, since it is the similar thing, that
I'm only relying on the principle. The facts are obviously different, the open market candidates, etc. But the principle is very important, my lord. Apex Court says that is violative of Article 14, 20, 16 and 21. And there is no other process which can be followed. So the marks in the selection exam is the only basis, my lord. So this is, I would...
Can you give a written note of your
I
submission?
definitely do that, my lord. If Lordship allows me to submit the note...
complicated question of law, the court might forget.
No, definitely. No, that is my intention to...
Small clue is missed. Then
No, absolutely. If Lordship allows me to submit my note, once respondents have given the submissions, because there may be something I may need to...
there is no problem in this thing, but you do not want them to prepare their
No, I
submission
can-
on the basis of your submission.
No, I can give it. If Lordship allows, I can give it.
Normally, see, after you complete, they will give a reply.
Very well, very well. I can submit it, my lord, next week also I can submit it. Today is Thursday.
Anyway, you just complete your.
Very well. So that was my second submission for today, the Supreme Court judgment, which I say covers my case, my lord. There is also, my lord, a division bench judgment from this honorable.
This is not reported anywhere, Mr.
My lord, at the time I took a printout, it wasn't, but this was in May. After that, I haven't checked, my lord. I'll check, my lord. Also, my lord, if I can direct Lordship's attention to a division bench judgment of this honorable court. This is the roster case, my lord. Again, Justice Banerjee heading the bench, my lord.
Yes.
This is the roster case. If Lordship looks at the last paragraph, my lord, second page.
Yes.
It is made clear that the validity of the roster system has not been gone into. It is also clarified that the gradation list in every post will have no nexus with the roster system, as the gradation list will be governed by the merit positions occupied by the persons collectively recruited. So, because of the roster, because of reservation, they received appointment 2 years prior to me. But Justice Banerjee, division bench says, roster has no nexus with the gradation list. Gradation list will be governed by the merit positions.
Why you are Why you are placing this? Are you trying to contradict the situation which prevailed after the single bench judgment of Justice Banerjee?
My lord, single bench judgment by Justice Banerjee is there. It is there.
But then what was the basis in that case?
The basis
Single
was...
bench, the basis on which the single bench judgment was passed?
My lord...
Even if it is for entry
Yes,
level
ma'am.
post.
Yes, ma'am.
Then is it not that this is something...
If Lordship is indicating that there appears to be some contradiction between
we
division...
do not know. That is perhaps the understanding. If there is wrong in the understanding of the court, you
No,
correct it.
Lordship, I cannot fight the record. So there is...
To some extent,
there is
some confusion is there.
There is a contradiction. There is a contradiction, but this is a division bench judgment. The same Justice Banerjee in this bench, in this order, is very clear. He could not be clearer that gradation list for every post, any post, will be governed by the merit positions occupied by persons collectively recruited. So we have been collectively recruited. My merit position is above private respondents. Gradation list will have to be governed by that. So this, my lord, I would again humbly submit, is again instructive and supports my contention that junior grade...
But in such a case, then if you had to go by this view expressed here,
yes, ma'am.
Of course, we do not know what exactly is meant by saying roster system. Anyway, what
Sorry,
would be the
roster system?
Is it like anyway? Then this basically, if it is to be applied, then this will have the effect of dislodging the position which appeared pursuant to the single bench judgment.
No,
which,
no, because single bench judgment, as Lordship has also noticed, was for the junior grade. Now we are in the senior grade. Now all of us are in the senior grade. Senior grade will have to go by the rules 16.4, where merit, my position in the merit list will have to be looked at. The other reason I was highlighting para 27 of this judgment, of the Supreme Court judgment, was Supreme Court in this case has said that because of these problems, because of the fact that you've been adopting a wrong practice or you have adopted a wrong practice, you have to recast the gradation list. So the power to recast that gradation list is there with this Honorable Court. Because Supreme Court was exercising jurisdiction under Article 32. Multiple times Supreme Court has said power under 226 is more than Article 32. We'll not go into constitutional issues right now. So,
Greater and wider has different meanings. Anyway.
My lord. Point being, my lord, that Supreme Court judgment, Honorable Division Bench judgment, they are all saying the same thing. Previously, on the first occasion, I had relied on Crispilla T. Sangma's judgment, my lord. That is also by Justice Banerjee. My lord was also part of that bench, my lord. If I can refresh on this is at page 44 of the writ petition, my lord.
Of the writ petition?
Writ petition. Page 44
yes.
is a judgment passed by Justice Thank sitting singly. In this judgment, my lord, what Justice Thank held was that para 12, my lord. Para 12, my lord.
Just
page 54. Page 54,
yes.
54, para 12. Though it has been reiterated and held in various judgments that the date of entry into a service is the safest rule to follow, while determining the inter se seniority between one employee or the other, however, in the circumstances such as in the present case, where there is the presence of rules framed under Article 309 of the Constitution, which creates a distinction as provided in Rule so-and-so, the contention that the respondents numbers 5, 6 and 7 were not born in the service cannot be accepted due to the presence of a specific rule. Moreover, the interpretation of the petitioner to bring in a date of formal appointment into Rule so-and-so cannot be accepted, as this factor is clearly not present in the rule. The judgments placed by the learned counsel for the petitioner are therefore of no assistance in the facts of the present case. In this case, my lord, the same contention was advanced, that petitioner in this case had joined prior to the respondents. So petitioner was claiming seniority because I joined the service prior to you. Justice, Thank said no. Your joining the service cannot be a factor. We have to go by the rules, my lord. This judgment, my lord, was challenged before the division bench, where my lord had also sat. Next page, my lord, page 56. Page 56, my lord, is the division bench judgment. Appeal was dismissed, my lord. Para 3, if lordship looks at.
Yes.
Para 3, ordinarily, when recruitment for many positions in the same post is conducted through a competitive process, the person who gains appointment at the end of the process are graded according to their merit. In other words, persons who obtain higher marks in the relevant competitive examination are placed higher in the gradation list as against persons who obtain lower marks. In many cases, rather erroneously, the gradation list is mixed up with the reservation list. While the reservation list indicates how many of the recruits at a particular recruitment process would have to come from among reserved categories, the gradation list prepared at the end of such a recruitment process has no nexus with the roster and has to be prepared according to the inter se merit based on the marks of the candidates at the particular process. If lordship turns the page kindly, para 7, my lord.
Yes.
It is plain to see from the inter se seniority list of so-and-so that while the appellant herein ranked 68 in the merit list, the 3 private respondents ranked 58, 55 and 53rd in the same merit list. Since it is also evident that the merit list pertain to the same recruitment process, irrespective of when any individual actually joined the service, the seniority and gradation list would have to be on the basis of the marks obtained in the recruitment process and the position in the merit list.
Now again it comes to that, seems that there is some conflict then
between
come to the single bench decision.
Lordship, I cannot run away from what is evident.
If that is the basis.
So division bench has
now
made it.
Whether these are distinguishable.
My lord.
Just the proposition in the single bench judgment and the division judgment, the part which you have read out just.
Yes,
now.
ma'am.
Can a distinction be drawn so far as the facts and situation of the cases are concerned?
My lord, I would request, my lord, I would humbly request that the single bench judgment of Justice Banerjee will have to be read in the context in which it was passed. The context, my lord, was for the junior grade. Now, once we have moved beyond the junior grade, I would again respectfully submit, any reference to Justice Banerjee's judgment would be an OTO's reference, my lord. It'll be an unnecessary reference for the reason that Justice Banerjee's judgment was regarding a particular fact situation or a particular issue, my
That
lord.
stage is over now.
That stage is
There remains no controversy with regard to the stage.
Yes, my lord. We are in the senior grade now. Now we have to take a fresh look at the matter. The gradation list which has been published is still continuing the same Justice Banerjee's position as far as the junior grade is concerned. Now we are in the senior grade. We have to be governed by the rules.
Now, what is the basis of promotion to senior grade?
The
On
criteria.
what basis
Criteria.
person is promoted? Criteria. Yes.
That's at Rule 22, my lord. Rule 22.
What does it say?
Ability, integrity, etc. My lord.
So there is a selection board.
My lord. My lord.
And is there anything like holding of examination or it is your...
No.
And then thereafter,
My lord.
after the candidature of all the eligible persons are considered,
Yes, ma'am.
do they prepare a merit list or select list or...
My lord, Rule 23, if Lordship recalls, states that the board will prepare a list as far as promotion is concerned, for the purpose of promotion. So there are in order of ability, integrity, etc. My lord.
So that is merit. If you
So,
say ability, integrity, that comes to merit then.
more or less, my lord. I mean, summing up.
No, see,
Summing up.
Where is the rule then? If rule covers of the thing, then why to go into all those?
Ability, integrity, and character, my lord. Rule 22(1).
Just a minute. Let us read 22 and 23.
22(1). A member of the service in the junior grade time scale shall be eligible for promotion to the senior grade time scale, but no member of the service shall be promoted unless he has served in the junior grade time scale for a minimum period of 7 years and the governor is satisfied about his ability, integrity, and character. Seniority is not mentioned. And the list that is prepared by the selection board, that is at 23. If Lordship allows me to read 23.
What about suppose 2 of 222? Just a minute.
The appointments to the senior grade time scale shall be made by the governor from a list of suitable members of the service as prepared from time to time and received as and when necessary by a selection board consisting of the following, namely so and so. If Lordship goes on, 23.
Just a minute.
Is
Now, the selection board which prepares a list from time to time.
Yes, the seniority of members of the service promoted to the senior grade time scale shall be in the order in which the names are arranged by the selection board under so and so for the purpose of promotions to that grade. So, selection board also prepares a list, but that list is a very different kind of list. It's not a merit list or anything. It is for the purpose of promotions. I'm grateful that Lordship
Then
has.
once you are promoted to the senior grade, then 16.4 will come into play again.
16.4.
And then seniority has to be fixed in strict adherence to the 16.4. That is
That's my the sum total of my case. I'll submit written submissions if Lordship requires before they.
Give the notes so that at least that way.
But Lordship will allow me to supplement those submissions if required later.
Court doesn't have much, like expertise in this service matter is concerned.
Lordship.
What matters is that the understanding should be correct.
Absolutely. That is the endeavor to assist this honorable court. If Lordship requires by next week also, I can give us.
Please give it. That will help.
A short
Just give the notes.
Points. Yes.
And the decision which you have referred, if you can give a reference of that.
I'll do that. I'll enclose copies also.
So you have concluded your argument.
I have concluded.
Yes.
Subject to what they say, I may have to respond.
You conclude?
Yes.
May it please your Lordship. Lordship, first, before going into the affidavit, your Lordship.
Yes.
The contention raised by the writ petitioner, your Lordship.
The application of 16.4, whether that will apply or not, that is what is needed. See, single bench judgment.
Lordship, Lordship, first the writ petitioner will have to make the start very clear first. Because at what time they rely heavily on Rule 22.
You are appearing for which respondents, Mr. Sulay?
Lordship, 1 and 2, your Lordship. Still.
Okay. And this one argument will cover up all the cases.
Yes.
All cases. Same.
Same.
Yes. Yes.
And on the other hand, your Lordship, they cannot go back and take shelter under Rule 16.4, your Lordship, by relying in the judgment of Krish Pilati Sangma, your Lordship. Because they also rely in this judgment to contend, your Lordship, that I'll come later on, your Lordship.
Please go ahead.
I'll come later on. Before coming, your Lordship, as I have submitted, your Lordship, to the affidavit, your Lordship, kindly see, your Lordship.
Affidavit of?
My affidavit, Lordship. First, your Lordship, I'll take, your Lordship, to paragraph 15, page 16 of the writ petition. It is under pleading, your Lordship.
Just a minute, Mr. Sulay. Just allow the court to have the
Lordship. I'm sorry, your Lordship. Page 16 at paragraph 15, your Lordship.
Page 16, paragraph?
15, your Lordship.
Of your affidavit?
No, your Lordship. A writ petition, your Lordship. Of the writ petition. Writ petition.
Yes, please.
Lordship, kindly see that the fact that the promotion conducted on 7/3/2000 and so and so appear to have been conducted under the provision of Rule 22 of the MCS Rule 19 means that the said promotion were conducted after following the procedure prescribed under the Rule 22. So that is their pleading, your Lordship.
So 16, if that is their pleading, then what you are trying to contend?
Lordship, they cannot go back to Rule 16, your Lordship, by relying in that judgment of Kapila Sangma.
This court has not followed. Yes,
Lordship, their contention is done for the promotion to next higher skill, your Lordship. The promotion should have been conducted under Rule 22-23.
That is what they do not say. They say it's appeared to have been conducted under provision so and so. They do not say it should be conducted, isn't it?
Yes, your Lordship, that is their argument. It should have been conducted And as per Rule 2223, Your Lordship.
Just let us read the whole passage.
Kindly see, Your Lordship, that the fact that the promotion conducted on 7/3/2022 and 28/7/22 appear to have been conducted under the provision of Rule 22, Your Lordship. So,
Appear
it
to
is,
have been. So that is a statement.
yes, Your Lordship. So it is their pleading, Your Lordship.
No, that means you want to say the statement would mean that their contention is that Rule 22 will be applicable.
Lordship, yes.
That is what you want to say.
Yes, Your Lordship. Yes, Your Lordship. So we have done, and accordingly, Your Lordship, kindly see, Your Lordship, the
Just a second. Just a second.
where is that Rule 7, notification 7.3 page? 7.3. Page 61. Page 61. Yeah. 61. Can you see, Your Lordship? Whether Lordship got my point or not?
No, we are trying, but then apparently it doesn't seem so. You see, it's a kind of statement that which they said it appeared. There is nothing of their admission that they say that it is prepared under Rule 22 or Rule 22 is applicable. Should be
Yes, Your Lordship, that is their argument. That the next promotion.
We take it to that. Whatever you say, we'll
So
go
it
by
is
your
on their
record
pleading, Your
assumption.
Lordship. It is there on their pleading that the promotion, Your Lordship, that is the notification issued on 7/3/2022, Your Lordship, kindly have page 61.
See, Mr. Sulai,
Lordship.
what is needed is that just you address the submissions made by Mr. Jindal. Now, his contention is that, you see, this seniority has to be fixed by following the provisions of Rule 16.
Rules, I'll come to that, Your Lordship. I'll come to that.
That
Your
is what
Lordship.
his case is.
Lordship, I'll come to that. I'll come to that, Your Lordship. Later on, I'll come to that, Your Lordship.
Yes, please.
I'll come to that. Lordship, kindly come to page 61.
Yes.
This is the notification, Your Lordship, promoting the private respondent, Your Lordship. The private respondent under Rule 22. And Lordship, kindly note.
This is impugned, isn't it? That is the
This
impugned.
is not impugned in the writ petition, Your Lordship.
Okay.
Lordship, kindly have the relief claim
Just
in the
a
writ
minute.
petition.
Just a minute, Mr. Sumai. Please go a bit slow.
Lordship, I'm sorry. Lordship.
This court's understanding is very slow, so that is what. Yes.
Lordship, kindly have page 61, annexure 6 to the writ.
This comes after promotion, isn't it?
Lordship,
This notification?
yes. Lordship, yes.
Yes.
This 7/3/2022, Your Lordship, this has been issued under Rule 22 of the MCS Rule 1975. Lordship, kindly note, this was not questioned in the present proceeding.
Yes.
It wasn't questioned.
Mr. Jindal contention is that this will apply only for the purpose of promotion, nothing beyond.
Yes, this is only, this notification of 7/3/22, Your Lordship, has been done in tune, in accordance with the Rule 22/23.
Okay.
As admitted by the writ petitioner at para 15 of the writ petition. What they have challenged, Your Lordship, Lordship kindly come to page 21.
See, he has no grievance with this also. So far as this notification is concerned, he doesn't have any grievance. It appeared to. He has interpreted Rule 23 according to him that this will apply, this will lose its relevance once promotion is accorded.
Lordship,
And
kindly
for thereafter for fixing seniority, then you have to come back to 16.4 and you have to apply that.
Lordship, kindly
That is what the crux of argument of Mr. Jindal, if court has
kindly read, Your Lordship, the contents of the notification. The following MCS officer are under Rule 22 of the Meghalaya Civil Service 1975 temporarily and until further order promoted. This is the promotion only, Your Lordship.
That's all right.
This is the only promotion only, Your Lordship.
There is no grievance with it. See, like this is okay. We understood that. We are not disputing your submission, Mr. Shulai. But then what we want is basically to address the court on application of 16.4 as contended by you.
That I'll come later, Your Lordship.
What requires for you to convince the court is about the applicability of same list so far as fixation of seniority.
That I'll come later. I'll come later, Your Lordship. I'll come later to that. That I'll come later, Your Lordship. What they have challenged, Your Lordship, kindly have page 21 of the writ petition.
Page 21.
21, Your Lordship. What is their grievances, Your Lordship?
Yes.
Is the letter dated 17/1/2024, Your Lordship.
Yes.
That, Lordship, will find it at page 85.
That is the only prayer in the
Lordship, and also to revise the credition list of 22/8/22 in accordance with Rule 16.4, 22 and 23 of the MCS Rule 1975. Then, Lordship, kindly come. What is the
page 85?
85, Your Lordship.
Yes.
This is the letter issued by the Undersecretary to the Government of Meghalaya Personal and Administrative Reform A Department to the writ petitioner number 1, Your Lordship. With reference to your representation on the subject cited above, I am directed to inform you that the credition list published in so-and-so is in continuation of the credition list dated 4/3/22 in pursuant of the High Court judgment 10/2/2022. This is the judgment passed by the then Chief Justice, Your Lordship, in the series of litigation between the writ petitioner and the private respondent, Your Lordship. Then, Lordship.
That is the single bench judgment of
Lordship, yes.
Justice Banerjee.
Kindly see, Your Lordship. Kindly see, Your Lordship. They are aware, Your Lordship, they are aware of this High Court judgment, but they have chosen not to state even a single sentence, Your Lordship, in the writ petition. Lordship, whether this is not a suppression of facts, Your Lordship, a material fact, Your Lordship. Whether, Your Lordship,
there is no averment in the writ petition.
There is no averment. I have not seen, Your Lordship. Lordship, they have just
yes
mentioned at para E, Your Lordship.
So that is not a total suppression, isn't it? Partial suppression.
Lordship, yes.
Okay.
Can you see, Your Lordship?
Yes. So, what you say that is apparently not correct, Mr. Sulay. There is a mention of that.
There is a mention, Your Lordship.
Then?
There is a mention.
No suppression then.
Lordship, can you see, Your Lordship? There is a mention. They are not bothering also to annex a copy of the judgment.
That is a different thing.
They are not.
Anyway, so at least we are not recording the submission that is suppression.
Lordship, yes, they are not bothering, Your Lordship. They should have come. This, Your Lordship, they should have at least have the courtesy to annex, Your Lordship, to enable the court what is there in the judgment.
But then he has placed it during the course of hearing.
Your Lordship, it should have come, Your Lordship. They are aware, Your Lordship, this has been quoted in the order impugned.
Yes, what else? You just carry on.
Then, Lordship, kindly come to the affidavit filed by the state.
So, your thing is that they have not enforced the judgment, okay? And then what happens? Come to annexure?
Lordship, yes, this is a sort of tactic, Your Lordship, to mislead.
Anyway, it's all right. And then just come to next month, Mr. Sulay. What?
Lordship, kindly come to page 35. This is the earlier writ petition, Your Lordship.
Page 35 of the writ petition.
No, Your Lordship. Now I am taking Your Lordship to the affidavit.
Of yours.
My
Affidavit
affidavit, Your Lordship. Yes.
What you are trying to say from
Lordship,
there?
because by this, Your Lordship, by taking this, Your Lordship, I'll come to Rule 16.4, Your Lordship. I'm coming to Rule 64.
Page 30?
Page 35, Your Lordship.
Yes.
Lordship, kindly come to, then, Lordship, kindly see, this is the petition filed by one of the private respondent, and in this writ petition, Your Lordship, at page 45, the writ petitioner, Your Lordship,
Page 45?
Lordship, yes, of my affidavit, Your Lordship.
Yes.
They were respondent, Your Lordship. And what is the nature of challenge in that?
That you have already made us known about those things, that earlier round of litigation.
Lordship,
And then they
Lordship,
all are the
because
parties.
I'm taking Your Lordship, what is the challenge there, Your Lordship?
Yes.
Lordship, kindly come to page 57. Page 57, Your Lordship. Kindly see, Your Lordship. In the premises aforesaid, it is most respectfully prayed that Your Lordship would be graciously pleased to issue rule, call for the record, and after hearing the parties, be pleased to set aside and quash the credition list published on 20th June 2014 by memo number so and so. That, Lordship, will find it at page 189, Your Lordship. And the relevant page, Your Lordship, will find at page 201. 201.
That is the notification.
No, Your Lordship, the list, the credition list, Your Lordship. 189, Your Lordship, is the credition list dated 20th June 2014, which was challenged by the private respondent, Your Lordship, as a writ petitioner in those writ petition. at page 189, Your Lordship. And the relevant page, Your Lordship, so far the writ petitioner and the private respondent are concerned, Your Lordship, it is at page 201, Your Lordship. Lordship, kindly have serial number 31.
This is at page
201, Your Lordship.
201.
Lordship, yes. Serial number 31, Shimati Bayan Timan Bla. She is the lead petitioner. Correct, no? Lead petitioner. And the private respondent here in Your Lordship will find at page 202, Your Lordship, at serial number.
These are the situations which were in existence prior to the filing of the first round of litigation, is it?
Your Lordship, yes.
That is okay. That stood altered after the judgment came.
Lordship, yes. So what happened, Your Lordship? Then, Lordship, I'm taking. Then, Lordship, another writ petition, Your Lordship. Kindly come to page 124
of your affidavit.
Lordship, yes. This is another writ petition.
Yes.
That is writ petition 306 of 2018, Your Lordship.
Yes.
And who are the parties, Your Lordship, there? Kindly come to page 134.
How many writ petitions were filed before?
Lordship?
Concerning the same subject, how many writ petitions were there?
A series of 3 or 4 writ petitions.
But then praying for same relief, isn't it?
Lordship,
and
yes.
that were decided by one judgment.
Lordship, yes. Lordship, kindly have page 134 at serial number 3.
Yes.
The lead petitioner was the private respondent in that writ petition. And Lordship, kindly come to page 146.
No, this is also a respondent. Serial number 3 is respondent, isn't it? Not the petitioner.
No, I mean, Your Lordship, the writ petitioner now was the private respondent in that earlier litigation, Your Lordship.
Yes.
And what is the relief claim, Your Lordship? Same. Against that, Lordship, kindly have page 146.
That is okay. That is probably all those things is discernible from the judgment of Justice Banerjee, isn't it? Single
Lordship,
judgment.
yes.
And that part, this part of the
Then-
things are not disputed, I think.
Then, Lordship, kindly have page 212, Your Lordship. This is the judgment passed by the then Chief Justice, Your Lordship.
Yes.
Lordship, kindly see. May I read it, Your Lordship?
Yes, if you think it is relevant, you should read out. There is no problem.
The only question which fall for consideration in this matter pertain to the seniority between group of persons in the Meghalaya Civil Services and the Meghalaya Police Services. The principal ground urged by the writ petitioner is that the writ petitioner were appointed earlier in point of time than the private respondent herein. There can be no question of ascertaining any seniority between the writ petitioner and the private respondent. Lordship, kindly see to a rather absurd situation is presented on behalf of the state. Kindly note, Your Lordship, the state claimed that in terms of Rule 16.4 of the Meghalaya Civil Service Rule 1975, the seniority between the person who underwent the process of examination together has to be determined irrespective. When such person may be appointed, the submission has to be repelled without any further consideration. Lordship, kindly see, Your Lordship, the writ petitioner and the private respondent, Your Lordship, they appear in the same competitive examination held conducted by the Meghalaya Public Service Commission. Some some were appointed, Your Lordship, in 2010. They were appointed, Your Lordship, in 2012 or 2000.
In spite of the fact that they were higher in the merit list,
Lordship, yes.
because of the operation of the roster system.
Lordship, the contention of the state at that particular point, Your Lordship, is that by operation of Rule 16.4 of the MCS, Your Lordship, because we belong to the same selection process, Your Lordship, if A comes later and B comes before, Your Lordship, if B is on top of the selection list published by the Public Service Commission, he should be senior.
That is in order of merit. That is
in order of merit, that contention of the state has been repelled, Your Lordship, in this judgment. And what is the...
So that point of time, you were supporting him.
Lordship, yes. So what happened, Your Lordship? What happened after this judgment, Your Lordship? After this judgment, Your Lordship, the writ petitioner, Your Lordship, they were happy. They were happy. They did not pursue any. They did not pursue. Then sometime, Your Lordship, in the year 2022, in the
these three matters are disposed of by one judgment.
Lordship, yes,
but then there is no reflection of that.
Lordship, no. It is there, Your Lordship.
Right at the top left-hand corner.
That is the numbers are it.
Yes, those are the three.
If you see the start of the judgment, the only question which falls for consideration in this matter.
Lordship, kindly have 219 of that judgment and paragraph 22. Yes. WPC number so and so are allowed by holding that the 2000 recruit of the entry level post have to be regarded as senior to 2012 recruit to the same entry level post, irrespective of whether the further concern may arise in determining the scheme for promotion to the next level. Can you see, Your Lordship? WPC number so and so are allowed by holding that 2010 recruits to the entry level post have to be regarded as senior to 2012 recruits to the entry level post, irrespective of whether future consideration may arise in determining their cases for promotion to the next.
Meaning thereby this will not have a bearing so far as the future
Lordship.
Consideration is concerned.
So now, Your Lordship, as I have submitted, Your Lordship, this judgment, Your Lordship, this judgment had upset the accreditation list of 2014, and then after this judgment came the accreditation list of 22/8/2022, Your Lordship,
which you said is not. Oh no, that is the selection. Yes.
After this judgment, Your Lordship, then came the notification dated 22/8/2022. So
that is all right. You see, Mr. Sulai, Mr. Jindal's argument is somewhere else. Now, what you are placing basically would reveal the factual situation which was there.
Because what happened
with the passing of the judgment, single bench judgment, the position with regard to the entry level post stood settled.
Then
and then after all of them, the petitioner and the private respondents were promoted to senior grade. Now we are basically concerning with that determination of seniority in the senior grade, nothing else.
A Lordship kindly see. Then a Lordship take kindly have.
Whether 16.4 will be applicable, or
Lordship
whether
kindly
the proposition of law sought to be projected by Mr. Jindal by placing reliance on that apex court decision
that
and
in
also
my
by the division bench decision.
That in my humble respect.
Those proposition will apply.
That
that is only one thing. What
that in my humble and respectful submission, Your Lordship, so far that judgment of the Supreme Court, Your Lordship, will not be applicable in the factual situation in this repetition, because, Your Lordship, in those cases it is a case of direct recruit versus promotees. So it will have no bearing in this case, Your Lordship. In this case, Your Lordship. Lordship kindly have Rule 16.4. High Court.
Rule
16.4.
16.4. Yes, please.
Lordship kindly have 16, then come to 4.
Yes.
The seniority of the member of the service recruited after the commencement of this rule shall be in order in which their names appear in the list prepared sub Rule 4 of Rule 6 or approved under Rule 8. Kindly have Rule 6, Your Lordship.
Yes.
Recruitment by competitive examination. A competitive examination for recruitment to the service shall be held in interval at the governor in consultation with the commission from time to time determined. The examination shall be conducted by the commission in accordance with such rule and syllabus as the government may from time to time make in consultation of the number of vacancies to be filled up on the result of such examination. There shall be in favor of candidate to shield caste and shield tribe. The Lordship kindly see the Commission shall prepare a list of all candidates who have qualified in the examination in order of merit, which shall be determined in accordance with the aggregate marks obtained by each candidate, and if 2 or more candidates obtain equal marks, the Commission shall arrange them in order of their relative merits, which shall be determined in accordance with the general suitability of the candidate for appointment to the service. The list shall be forwarded to the Governor and published in the Gazette of Meghalaya.
So what are you trying to say by reading this?
Lordship, what I'm trying to say, Your Lordship, because Rule 16, Your Lordship, said the seniority, Your Lordship, will have the seniority will have to be counted on the basis of the list, on the select list published by the Meghalaya Public Service Commission, Your Lordship. Lordship, whether Lordship got my...
No, see, like the sum and substance of your submission is that then 16.4 applies to a situation where recruitment is made on the basis of direct competitive examination.
Competitive examination.
Is it correct? That is what...
Lordship, yes. Lordship,
so it will lose its applicability. So it will not apply anymore after the person is promoted to seniority.
Lordship, I'll not say whether apply anymore or not. I'll not say, Lordship.
16.4.
But because.
No,
but because, Lordship.
If the question comes whether 16.4 will have applicability in the fixation of seniority in the senior grade or not, what will be your answer? What will be your response?
Because there is a hurdle, Your Lordship. What is that hurdle, Lordship? Because of the judgment of the...
No, that is... otherwise what? Rule will apply or not? Judgment will see which way to deal with it.
Because of that judgment, Your Lordship. And that judgment remains, Your Lordship. We cannot ignore that judgment, Your Lordship.
Tell us about the application of 16.4. Whether 16.4 will still apply at the time when this impugned order was passed, impugned gradation list was.
Lordship, as I have said, Your Lordship, there is a hurdle. There is a hurdle. What is that hurdle, Your Lordship? That is the judgment of the learned, the then Chief Justice.
See, the learned judgment of...
Can you see, Your Lordship?
That applies only to the entry-level post. It speaks. That is specific on the last part. Now, what remains is that the crux of the issue, you see here, is that the application of 16.4 whether this will still apply after the incumbents are promoted to senior grade or not. Now you have to just address the court on that, and that is where probably the solution lies.
Lordship, because Your Lordship, as I have submitted, Your Lordship, there is a hurdle. What is that hurdle, Your Lordship? Because as reflected in the impugned order, Your Lordship, because the kindly see, Your Lordship, the credition list of 2014, they were above, Your Lordship.
See, tell us in the senior grade, is there any direct recruitment?
No.
It is only a promotion.
No, Your Lordship. This is
so whether Rule 6 will still be apply there.
Lordship, the difficulty, Your Lordship, the difficulty as I have submitted, Your Lordship, is that because of that judgment.
If Rule 6 apply, then 16.4 comes into play. If Rule 6 doesn't apply, whether 16.4 will definitely.
Lordship, because because of that judgment, Your Lordship, the judgment of the Honorable Chief Justice, Your Lordship.
See, that has lost its operation. Forget about that. That determines that position at the entry level. We are not at all concerned with entry level. You come to a situation after Rule 22, 2 and 23 here. See, after the promotion, the seniority which was there in terms of fixed in terms of the earlier and these things, whether that would take a change. And if it takes a change, then under what provision of the rule or in which manner?
Lordship, kindly see, as I have submitted again and again, Your Lordship, there is a hurdle, Your Lordship. What is that hurdle, Your Lordship? That is the judgment of the then Chief Justice, Your Lordship. In 2014.
It means you want to say that minus the judgment, 16.4 would have been applicable? Lordship. Are you trying to say it?
Lordship, the implication should be like
yes,
that.
then you just say we will refer.
That would be the implication, Your Lordship.
Sulai, probably you need some more. You have to look at that part of the matter, because this is the class of issue. See, your argument with relation to application of 16.4 will have the most utmost important.
You see, Your Lordship. You see,
the argument
Lordship, kindly
Mr.
see, Your Lordship. 2014 credition list that has been upset.
Gone.
That has been upset, Your Lordship, because of the judgment.
He is not raising any grievance so far his loss of seniority in pursuant to the single
Then after that judgment, what credition list come, Your Lordship? The 22nd 8/2022, Your Lordship. And that 22/8/2022, Your Lordship, that has been a recast.
Are you saying just because it is the department has given a reply to their query saying that gradation is just prepared in terms of the judgment of the single bench?
Yes, Your Lordship.
His case here is that, see, his case here is that that judgment of the single bench lost its applicability once all of the concerned people are promoted to the senior grade. And that appears to be correct if you take into consideration the contents of the judgment.
Lordship,
only with regard to the fixation of seniority in the entry level post.
Lordship, kindly see
Tell us one thing, just minus any litigation and all. Normally, if you fix seniority,
Lordship,
in the senior grade, promotional post, what rule you apply?
There must be a rule, Your Lordship.
What rule?
There must be. Whether Lordship is talking about this case.
We are not particularly talking about this case, but then we are referring to this rule. In general, what rule will be applicable for fixation of seniority in the senior grade?
And this rule only, Your Lordship. There is no other rule.
What provision? What particular provision of the rule?
That is 22, Your Lordship. 22.
22.
22, Your Lordship. That is 22, Your Lordship.
But then now if we come to the facts of this case, in the facts and circumstances of this case, whether 22 will still apply or 16.4 will apply, or whether both will apply.
Lordship, because as I have submitted, Your Lordship, that Rule 16.4, Your Lordship, because of the judgment, that will have no more application, and Rule 22 will come into play, Your Lordship.
So now at least you are saying clearly. All along you are not saying. You are saying that 16.4 will not have applicable, will not apply anymore. Isn't it?
Yes,
It
Your
is only
Lordship.
Rule 22.
Because of that
what
judgment.
happens if you come to the impugned notification? It refers to 16.4.
No, Your Lordship.
Which way you deal with that situation?
Lordship, that might be
Do not say
due to
anything by using
oversight
word
in
might
law.
be. Might be, cannot be. You just say if it is. If it is, then you
oversight,
say.
Lordship, because there is a judgment.
Have you said anywhere in your affidavit that this is through oversight?
No, we have. We have not said.
Then?
Your Lordship, we have said, Your Lordship, that there is a judgment. That the impugned letter, Your Lordship, also said very clearly, because of the judgment passed by the Honorable High Court, that accreditation list of 22/8/2020 has been issued.
But then the fact remains that then in such a case, you see, that notification, if it is the judgment is the only basis, then this notification becomes questionable because the judgment is confined only to the entry level post.
No, Lordship, kindly.
Come to the judgment of the single bench. Come to page 219 of your affidavit of opposition. What does it say? Paragraph 22. What it says?
The WP are allowed by holding that the post are allowed by holding that the 2000 recruit to the entry level post have to be regarded as senior to 2012 recruit to the same entry level post or whatever future condition may arise in determining their cases for promotion to the next level.
So irrespective of, so that is where.
But
probably Mr. Sulai, do not know whether you had the idea of Mr. or the line which Mr. Jindal will be adopting today or not.
Yeah, I got Your Lordship. His argument is done. His argument is done. The Rule 22 or 22 for the next
this judgment lost its operation once the seniority in the entry level post is fixed.
It's
now,
fixed.
see,
It's
so long
fixed,
they remain
Your
there, the judgment holds.
It's fixed, Your Lordship.
Moment they are promoted to the higher post, like senior grade post here, this judgment loses its applicability. And that appears to be correct if we go take into consideration paragraph 22 of this judgment. We do not know whether you read into it differently or not. Okay. Now, are you trying to contend that this judgment would still hold its feet?
What I'm contending, Your Lordship, because here, Your Lordship, he also has sought for upsetting, Your Lordship, that accreditation list of 22/8/2022.
What he says is that this reference to their previous seniority is not at all applicable when you seek seniority in 22.
That is the relief claim in the writ petition, Your Lordship. That is the relief claim in the writ petition.
What?
For setting aside that accreditation list of 22/8/22.
Understand. But it's not that. Are you saying that this judgment will be applicable? This applies even fixation of seniority in the higher grade also. Beyond entry level post. Are you trying to say?
Yes, Your Lordship. Certainly, Your Lordship, because that Rule 16.4, Your Lordship, will have no effect.
No. This Rule 64 concerns entry level post. This judgment also concerns entry level post.
Lordship, yes.
But then judgment will have its operation and 64 will lose the operation. Is it your argument?
Yes, Your Lordship, because we have made that 20.
That is very strange. It seems very strange.
Lordship, kindly see 22/8, Your Lordship, as as per the impugned letter, Your Lordship, we have made that list, Your Lordship, on the basis of the judgment passed by the High Court. We cannot ignore, Your Lordship, that judgment of the High Court.
So, you maintain that this
Lordship, if I may clear my lord.
please do it. The court is getting confused. If you
Lordship, what has happened, my lord? What I can gather from the submission made by the learned senior, my lord, is challenging the gradation list, but also saying that he's not agreed.
you're talking about Mr. Jindal,
Yes.
are you? Yes.
He's not agreed.
See, Mr. Momin,
Yes.
the cracks of the argument
Yes, I
of Mr.
understand,
Jindal.
my lord,
Yes.
my lord. My learned senior is saying that after promotion, the judgment becomes
Loses
redundant,
sanctity.
loses its value.
Sanctity.
So, in counter
That is
to
that is one
yes,
that is one aspect
yes,
of the matter.
yes. In counter to that submission, my lord, first I want to draw lordship's attention to the background of the case as to why the respondent herein, my lord.
That you will do, Mr. Momin. You will come.
No,
We will come
but
to
that
you.
is very, very important, my lord.
We will come to you once Mr. Shulai finishes. We are not shutting you down. You have to address the court.
I will.
See, we are not closing
No,
the
my
matter
lord, I
now.
understand, my lord, but I'll just for clarity, my lord, if lordship allows me, so that I
No,
can...
no, we thought that you will be clarifying something
on
which Mr.
16.4 also, my lord. On 16.4 also, I'll come to that point directly, my lord. But let me just come to the background.
No, you come to your point when you are addressing the court.
Lordship.
Now we are concerned with Mr. Shulai. We thought that when you stood up, you will make some clarifications over Mr. Shulai's things.
The 16.4, my lord,
Because-
will lose its credibility, my lord. Once 16.4...
That is okay. That is okay. We'll take into consideration. You see, you do not start addressing the court right now in the midst of Mr. Shulai's thing.
Let him start.
You will have your.
Let him start also. I have no issue.
No, that is okay. But then you conclude fast. We'll continue in the second half then.
Lordship.
Second half. Or on some.
What? Mr. Jindal, when can you give your written notes?
Next week. Today we are on Thursday.
Next week,
Next week.
Second half.
After a week. So shall we have it next week or you want it to continue in the second half?
Next week, Your Lordship. Can you have next week, Your Lordship?
You please, Mr. Shulai, please clarify your stand. Your stand, so far as this court is concerned, is not getting you. Probably you are mixing them somewhere. Just give a revision to your thought and then...
If Lordship allows a very quick reply to what Mr. Momin had submitted.
Mr. Momin has not submitted at all.
My lord, the simple fact of the matter is Justice Banerjee's judgment has not amended the rules. So 16.4 is still in the rule book. So Justice Banerjee's judgment.
There is no question of amending, and he did not say that also. He only said that 16.4 loses it.
It cannot.
That is the crux of the issue. Which this court will
Absolutely.
See, this court will decide. Only thing is that we want try to get the clarification on the contention.
Understood.
What this court is trying to understand the submission or the contention raised by the parties. That is all. Anyway, Mr. Jindal, Learned Counsel for the petitioner, has concluded his argument. However, argument of Mr. Andy Shulai
Next week, one.
and Mr. A.G. Momin could not be concluded. Yes, sir. Let's wait for this is matter after
Lordship will have it on 26th if Lordship is.
26th.
Or 28th also will do, Lordship.
26th will be possible. 26th is the district council matters are there on 26th.
Then 28th, Your Lordship. 28th.
No, it's okay. Then we can try it on 26th also. There is no problem. 26th will be a problem for you.
My submission may not, the written synopsis may not be ready.
Okay.
Thursday
Then
maybe.
let it come after a week then. After a week, that is better.
After a week,
After a week.
Lordship.
Oh, no, list is better after a week for further hearing. We are not passing any order on submission of your written synopsis.
No, not okay. I'll submit it, my doctor. Not okay.
Apply, Your Lordship.
Hello.
me, please, Your Lordship.
Yes.
Your Lordship, by humble apologies, I beg to mention item number 32.
Mentioning about is over now.
Your Lordship, there's an interim in the matter. I'm just praying that
which
an
one?
interim may be the Flipkart matter,
that
Your Honor.
Flipkart matter.
Yes, Your
Interim
Honor.
order.
Interim.
Okay, then what was the order passed? It was adjourned.
For final argument.
Okay, just after this thing,
We were
then
allowed-
just say interim order.
Maybe.
If any passed earlier, shall continue till the next date.
Highly obliged, Your Honor.
Connected matters. 20 to 29.
And Miss Muskan Gupta.
R. Gupta.
Muskan.
M.
M-U. You can. Sure. Okay. Okay. Okay.